Welcome back to LexTalks, Legal Topics Simplified. You know the drill, law students. We're here to break down those tough legal concepts, and today, oh boy, are we going deep.
Deep.
Yeah, into the Transfer of Property Act of 1882. Specifically, we're talking rights and liabilities of, you guessed it, buyers and sellers. We've got cases, research. Exactly. So let's not waste time. You're all familiar with the Transfer of Property Act, I'm sure.
1882,
1882, but particularly Section 55. That's where it all happens, right? Obligations, rights, the nitty-gritty for both sides of a property deal.
It's a bit dense, though, wouldn't you say?
Yeah, it can be, which is why, before we even touch Section 55...
Got to lay the groundwork.
We got it, right. We got to talk about Section 54, the definition of a sale according to, well, the law.
Yeah.
Because it's not always as simple as it sounds.
Oh, it gets tricky.
It does. So hit us with it.
Yeah.
Legal definition of a sale.
Okay, so at its core, transfer of ownership of a property in exchange for a price. Seems straightforward enough, right? But here's the kicker.
There's always a kicker.
That price doesn't always have to be money, like actual cash.
Wait, really? So I could theoretically buy a property without handing over rupees?
Theoretically, yeah. Think family settlements. You and your siblings inherit some land, right? You agree one of you gets it, but they got to give the other something else valuable in return. Legally speaking.
That's the price.
That's the price. No money involved.
Wow. Okay. Any case law to back that up?
Yeah, we've got Chandrasekhar v. Abia way back in 52. Court actually said a family settlement, that's valid consideration for a sale.
So even though no money, the court saw value in that agreement.
Bingo. And it goes beyond family stuff, too. Prasanta VIC Ltd, 1955, a compromise decree. Like, from a legal dispute, that was the price for a property.
So two parties fighting over land, they settle, one buys out the other. That settlement becomes the price, essentially.
Exactly. It shows how flexible the act can be, you know. Recognizing value beyond just straight-up cash. But hold on, even with a price, there's more to a valid sale. You need competent parties. Everybody involved got to be legally capable of entering into a contract.
Right. No minors making property deals.
No minors, no one mentally incapable.
Got it. And obviously you need the property itself.
The actual immovable property, yeah. Land, building, whatever's being sold.
And the transfer of ownership has to actually happen legally, officially.
Where the title goes from seller to buyer, all crucial stuff.
Key elements. Which brings us to a case I found really interesting. Miscible Enterprises v. Vijaya Srivastava, 2003, right?
Ah, good one. You see why it matters.
I think so. But for those listening who aren't familiar.
In a nutshell, Miscible Enterprises, it hammers home the point that a sale can be challenged if there's no real agreement between the buyer and a seller who's actually legally able to sell.
So someone pressured into selling.
Or someone's selling something they don't even own.
The whole deal's off.
Yeah, the court's going to look beyond just the paperwork, make sure everything's legit and fair.
Protecting people from shady dealings. Now, once a sale's valid, that's where Section 55 kicks in.
The meat of the matter.
All those specific rights and liabilities.
Both sides.
For both sides. Important to remember, though, these mostly apply, in the absence of a contract to the contrary.
Meaning you can write up your own terms if they work for both sides.
So flexibility is there. The act's a framework, but not set in stone. Okay, let's talk seller duties before the sale happens.
Transparency time.
Right. Got to make sure everything's above board. What's the first biggie?
Disclosure. Any material defect, the seller, got to lay it all out. Think of it, you're selling, I don't know, an old textbook. Used textbook. You wouldn't hide the fact that it's missing pages, right?
No, that's just bad business.
Same with property. A material defect, that's anything major affecting the value, the use, could be structural, legal issues with the title, even something like a public right-of-way nobody noticed before.
Gotcha. So honesty's key, but it's also about avoiding lawsuits later on. Buyer finds a hidden problem, they can sue.
Absolutely. Laxmitas and Company vs. DJ Tata, 2019, court was clear. Sellers got to answer truthfully. Buyers questions. Buyers not happy. They can walk away.
So buyers, be inquisitive. Ask those questions, get those answers before signing anything.
Right on. And besides the defect thing, title documents, buyers got to see them all. It's like the property's legal history, you know? Chain of ownership, any issues, anything affecting the buyer's rights.
Like a legal pedigree.
Yeah, exactly. Buyer can check them out, make sure the title's clear. If not, red flags, renegotiate, maybe walk away.
All about transparency, protecting both sides.
Building trust, minimizing those future disputes. But the seller's duties, they don't just vanish once the sale's done. Post-sale, there's more.
So the story continues. What happens after the deal's closed? What's the seller still got to do?
Well, first things first, possession. Got to physically hand over the property to the buyer. Signing papers isn't enough. Buyer needs to actually use what they bought.
Like handing over the keys to the castle?
Literally. And this handing over, it's implied in the sale itself. It's a given. But it goes deeper. There's this thing called the covenant for title.
Okay, that sounds fancy. What's it mean in plain English?
Let's say you buy a rare first edition law book, right? Turns out it's stolen. The covenant for title, that's like the seller promising they have the right to sell, the title's legit, no funny business.
So a guarantee of authenticity for the property's ownership.
Exactly. Buyer's protected. Now, besides that guarantee, seller also has to give over all the official title deeds.
The final proof, the buyer's the new owner.
Right. And there's more. Any outstanding dues on the property, taxes, charges, those got to be cleared by the seller up to the sale date.
So a clean slate financially? Makes sense. What about legal stuff? Ongoing lawsuits or anything like that? Got to disclose those too.
Absolutely. Any pending litigation, got to be upfront about it. Can't have the buyer finding out their new house is part of some court battle. Transparency, transparency, transparency.
Makes sense. Buyer knows what they're getting into.
Right. Informed decisions, no nasty surprises. But we focused a lot on the seller. Let's not forget, the buyer's got rights. A&D responsibilities.
Oh yeah, they're not just along for the ride. They've got legal power too. Let's talk about that next time.
Absolutely. Let's shift the perspective. Welcome back to LexTalks. Glad to have you with us as we dig deeper into Section 55 of the Transfer of Property Act. We're all about empowering you law students to navigate the ins and outs of property transactions, so today's focus is on the buyer's side of the equation.
Right. Last time we tackled the seller's duties, all that transparency stuff before and after the sale. And some interesting cases too.
Oh yeah, like how a family settlement or even a court decision can be the price in a sale.
Yeah.
Not always about cold, hard cash.
Exactly. But now, let's flip the script. Buyers, you've got some serious legal muscle to make sure you're protected. Starting with, what is it? The right to rescind the contract.
If the seller's been hiding something, yep. Specifically, material defects.
Remind us, what exactly falls under that material defect umbrella? Give us a real-world example.
Okay, imagine you're about to buy a flat, excited, right? But then you go for an inspection and bam, cracks everywhere, the ceiling's sagging, it's a mess. That's not just a little fix-it-up job, that's a major issue impacting the value, the safety, the whole deal.
So stuff that really matters to the buyer, not just cosmetic stuff.
Right. And the seller, legally, they got to tell you about those problems up front. If they try to sneak it past you, you've got the right to walk away, no harm, no foul.
Like an escape clause.
Yeah.
Just in case things go south.
That's a good way to put it. And this isn't just theory, courts back it up. Remember Laxmitas and Company vs. DJ Tata. Buyer asked questions, wasn't satisfied with the answers, walked away, and the court said that's fair game.
So buyers, don't be shy. Ask those tough questions. Get the full picture. Knowledge is power. Now, what if the seller's playing games, like refusing to hand over the property after the sale's done?
That's where the buyer can flex their legal muscles and sue for possession. Basically, go to court, get an order saying, hey, seller, you got to give the buyer what they paid for, let him in.
It's about making sure the deal actually goes through, not just on paper, but in reality.
Exactly. Buyer gets to enjoy what they bought, live there, rent it out, whatever the plan was. But what if there's already someone living there? Like a tenant with a lease that goes beyond the sale date or some ownership dispute? Things can get tricky, right?
Yeah, that throws a wrench in the works.
Yeah.
What happens then?
It depends, really. Eviction might be needed, maybe negotiations. Could even involve proving ownership in court. It's not always cut and dry.
So property deals, sometimes they need a legal expert to untangle the mess.
That's why it's good to have a lawyer on your side. Now, let's talk about another big right for buyers. Suing for specific performance. Remember that from contract law.
Vaguely. Refresh my memory. What's it mean when we're talking property?
Okay, you've found the perfect house, signed everything, you're ready to move in, but suddenly the seller changes their mind, tries to back out. Heartbreaking, right?
It's a total nightmare.
That's when specific performance comes in. It's a court order that forces the seller to actually follow through, finish the sale as promised.
So the law is basically saying, nope, you made a deal, you got to stick to it.
Exactly. Especially important with property, because often it's unique. You can't just replace it with something identical. Your dream home, gone. No amount of money can really fix that.
So specific performance, it's acknowledging that sometimes money isn't enough. It's got to be that specific property. Are there any limits to this right, though? When might it not work?
Yeah, there are exceptions. If the buyer also messed up the agreement, or if forcing the sale would be super unfair or just impossible to do practically, then the court might not go for it.
It's about balance, looking at both sides. Makes sense. Now, another important right. Suing if the seller breaks the covenant for title. Again, that legal jargon, what's it really about?
Remember that rare law book example. Covenant for title, it's the seller's promise that they have the right to sell, the title's clean, no hidden issues. But what if that promise turns out to be a lie?
Like, there's some secret claim on the property that the buyer finds out about later.
Bingo. That's when you sue for breach of covenant. Get compensation for any losses because of that bad title. Imagine buying a place, then someone pops up claiming they inherited it years ago.
Yikes.
Yeah, seller's on the hook for that. It's about accountability, protecting the buyer from a messed up title. Now, another key protection, getting your money back if the sale fails because of the seller.
Seems straightforward. Seller messes up, buyer gets their money back, right?
Yep, that's the gist. Act's clear on that. Seller breaches the contract, any money the buyer paid, deposit included, they get it back. Fair's fair.
So seller decides to sell to someone else for more money, or maybe they didn't even have the right to sell in the first place.
Buyer gets a refund. And not just the original amount, they get any interest that would have been earned if the money wasn't tied up in this whole mess.
Makes sense. Got to make the buyer whole again. Okay, so lots of talk about the seller's duties, the buyer's rights. What about the buyer's responsibilities, though? What are they obligated to do?
Oh, they've got their part to play, too. Due diligence, that's key. Can't just take the seller's word for everything.
So, got to be proactive.
Absolutely. Inspect the property thoroughly, go through those title documents, maybe even hire some pros to do surveys or assessments, whatever's needed.
Like a property detective, looking for clues, making sure there are no hidden surprises.
You got it. The law expects buyers to be careful, do their homework, can't blame the seller for everything.
So it's a two-way street, shared responsibility. Seller discloses, buyer investigates. Now, documentation, that's got to be important too,
Right,
right?
absolutely. Every agreement, every little detail, everything in writing, crystal clear. That way, if any disputes pop up later,
You've got proof.
it's all there in black and white. Protects both sides. But before we wrap this part up, let's leave our listeners with something to ponder. We've talked about buyers, sellers, their rights, their duties. But what happens when other folks get involved?
Other folks, you mean like real estate agents, lawyers, those guys?
Well, they play a part, sure. But I'm talking about those who might have a claim on the property, even though they're not directly buying or selling. Third-party interests, we call them.
Okay, that sounds interesting. Can you give us a concrete example of what you mean?
Let's say someone inherits a property, but the current owner, maybe a sibling or something, decides to sell it without telling them, without their consent. That heir, they've got a claim, they're a third party.
Sounds like a legal showdown waiting to happen.
It could get messy. Or what if the seller already promised someone something related to the property? Like the neighbor has the right to use a path through the land to reach their own place?
So even though the neighbor isn't part of the sale, their right still affects things.
Exactly. Easements, those rights of way, they're a classic example. They're attached to the land. Whoever owns it, they got to respect them.
Yeah, so these third-party interests, they can be all sorts of things, inheritance, agreements, anything that impacts the property.
And the Act, it recognizes that those interests need protection, even if the third party isn't sitting there at the negotiation table.
Welcome back to LexTalks. We're wrapping up our exploration of property law in India, that Transfer of Property Act, 1882. Still with us? Good, because things are about to get even more interesting.
Yeah, we're diving into the deep end now.
We are. Remember that cliffhanger from last time? Those third-party interests that could really shake things up in a property sale.
Like hidden landmines waiting to explode.
Exactly. So for those who just tuned in, let's start with the basics. Who are these third parties, and why should buyers and sellers care?
Simply put, anyone with a legitimate claim on the property, even if they're not directly involved in the buying and selling, they're out there and their rights matter.
Okay, give me a real-world example, something law students can relate to.
Imagine, someone inherits a property, right? But the current owner, let's say a sibling, decides to sell it without telling them, no consent, nothing. That heir, they're a third party with a big claim.
Uh-oh, family drama turning into legal drama.
Could happen. Or think about this. What if the seller already granted someone rights related to the property? The neighbor, for example, they've got a right to use a path through the land to get to their own place.
So even though the neighbor's not buying or selling, their existing right affects the new owner.
Exactly. Those are called easements, rights of way, very common. They stick with the land no matter who owns it.
Okay, so we've got inheritance, agreements, anything that impacts the property. These third-party interests can be all sorts of things.
In the Act, it's clear those interests need protection. You can't just ignore them because they're not part of the main deal.
So this raises the question, what if you sell a property and completely forget about these third-party interests? Can the sale be challenged?
Oh, absolutely. If a third party can prove they got the short end of the stick, that their rights were ignored, they can go to court, try to protect what's theirs.
So the buyer, they could end up in a legal battle even if they thought they were buying a clean property.
Happens all the time. That's why it's crucial, both sides. Do your homework, uncover any potential third-party interest before signing anything. It's like a property investigation.
Digging deep, looking beyond the surface.
Exactly. Check public records, property documents, talk to neighbors, anything to make sure there are no surprises lurking.
And if it's registered, if it's in writing, it's notice to the world. No excuses later on. Oh, I didn't know.
Nope, ignorance is not a defense here. Okay, so what happens if someone does ignore these interests? What are the consequences?
Yeah, what can the third party actually do?
Well, it depends. Sometimes they can get an injunction, stop the sale in its tracks, prevent the buyer from moving in.
So they can basically halt the whole process.
If they act fast and their claim's strong enough, yes. Or they can sue for damages, get compensation for whatever harm was caused by ignoring their rights.
Like being denied access to that right of way or losing out on their inheritance?
Exactly. And sometimes, if it's proven that everyone just steamrolled over the third party to make the sale happen, the whole thing can be voided. Back to square one.
Wow, so these third party interests, they're not just theoretical, they have real legal power.
You bet. That's why this stuff is so important. Both sides got to be careful, do their research, get a lawyer involved, make sure everything's done right.
Absolutely. Well, I think we've covered a lot of ground today. Section 55, the Transfer of Property Act, it's complex stuff, but we've broken it down step by step.
From what a sale even means to the nitty-gritty of seller duties, buyer rights, and, of course, those third-party interests that can throw a wrench in the works.
A lot for law students to absorb, but hopefully this deep dive's given you a good foundation.
Remember, though, this is just the tip of the iceberg. Property law, it's vast. Every situation's unique.
If you're dealing with a real-life property issue, get yourself a good lawyer, someone who knows the ins and outs.
They can guide you, protect your interests, make sure you don't end up on the wrong side of a legal battle.
Couldn't agree more. Well, on that note, we wrap up another LexTalks deep dive.
Thanks for joining us. Hope you found it insightful. Keep studying, stay curious, and we'll catch you next time for another fascinating legal exploration.
Until then, stay legally savvy.